Hello and welcome to AWCI's Convention and INTEX Expo Reconstructed. Our webinar today is Navigating Uncharted Waters, Legal Ramifications of COVID-19. I am Anne-Marie Salvatelli, AWCI's Director of Education, and will be your host for today's presentation. Before we start, a few housekeeping items. All attendees should be on mute during today's presentation. However, we ask that you please mute your phones or computer microphones as well to ensure that we keep the line clear for our presenters. Should you have a question at any time during our presentation, please submit it using the question box in your GoToWebinar dashboard. We'll have a Q&A at the end of our presentation, and we do have a handout of the PowerPoint, and you can download the PDF from the Handouts tab on your dashboard. Today's presenters are Rich Capriola and Eric Coleman. Both are lawyers and partners with the Atlanta law firm Winter Capriola Renner LLC. Rich has extensive experience representing subcontractors and owners in all manner of construction issues, including delay claims, liens, bonds, negligent and defective construction, prompt pay claims, and related construction litigation, arbitration, and mediation. He is licensed in Georgia, New York, and Washington, D.C., and through association with local counsel, he has represented clients across the country. Eric Coleman serves as a board member for the construction section of the Atlanta Bar Association. His clients include owners, general contractors, and subcontractors, both large and small. His practice focuses on resolution of construction disputes, including delay, non-payment, and defective construction claims through mediation, arbitration, and litigation. So with that, I will turn this over to Eric and Rich. Thank you.
Thank you, Anne-Marie, and thank everyone for joining in today's webinar. We didn't go with a video webinar. You don't want to see us sitting in our pajamas in our home offices. That's where Eric and I are broadcasting from separately. So we were asked about a week ago to put together a webinar for the corona impact to the construction industry and the legal impacts of that. So we've put together what we think are likely to be and may currently be for some the effects being felt in the construction community on the legal front. So, Eric, if you change slide.
It's a little April Fool's Day cartoon.
Okay. The state of the legal system, we'll start there so you all know that when and if you need to enlist the services of the legal system, whether that's to file a lien, to file suit, if you have pending lawsuits, pending arbitrations, all of that has been impacted as the rest of the country. Many state and federal courts have entered executive emergency orders, which basically freeze in place the legal process for civil lawsuits, such as construction-related lawsuits and business lawsuits. It's difficult for anything to be heard right now by a court, even on an emergency basis. And there's anecdotal stories that we're hearing and seeing around the legal community of lawyers going to court on what they think is an emergency basis for their clients, and for their clients are emergencies, such as preventing trade secrets from being misappropriated, or other things that would usually get immediate attention in the court, only to be told by the judge that this is not an emergency under these current situations, under the current conditions that we're living in. So it is unlikely that a pay dispute, for example, that we may be experiencing in a construction job would rise to the level of getting immediate legal attention by the court. But that doesn't mean that we're relieved from obligations necessarily to file those claims. or to complete the obligations that we have outside of the courtroom itself. They are very different in every jurisdiction, and every court even has its own rules, and sometimes even a judge has his or her own standing order. An option that is available in a lot of construction cases is arbitration, which I've referred to and tell my clients is essentially a private trial. You pay to have a judge, usually a lawyer, sit as a judge for you in a private arbitration proceeding. And often the arbitration rules, such as the AAA's rules, have procedures in place for expedited emergency arbitration procedures. So if your contract has an arbitration procedure, you might be able to actually still be heard on an emergency basis if there's something that comes up that you need resolved in an arbitration, which is usually the opposite, where it's quicker to go to court on an emergency basis. But with all of these rules and laws out there, orders and executive decisions out there freezing up the legal process, it's really unknown what's going to be the impact of those in the future. For example, here in the state of Georgia, the Supreme Court said that all statutes of limitations are stayed for a period of 30 days. Well, there's real doubt as to whether that can be accomplished by a Supreme Court order when it's a legislative function that sets those statute of limitations. Our recommendation to you all and the takeaway from all of this is, regardless of what you might be hearing about, well, don't need to worry about timelines because everything's stopped and stayed. You should still focus on, and to the extent you're able, comply with the statutory and contractual timelines that you have. On the next page, we're going to see that these stay-at-home, social distancing requirements that have been imposed in many, many states around the country, but not uniformly by the federal government. So this chart shows us as of, I guess it was yesterday, and it's probably changed already, what is the state of the stay-at-home, and particularly where construction is deemed to be essential and non-essential on a statewide basis. So you'll see that in only 4 states so far has construction deemed to be non-essential. Construction has done very well with these rules that have been entered at a statewide basis, and construction projects generally have been more likely to be exempt from the regulations than most other businesses. And in those 4 states, New York, Pennsylvania, Washington, and Michigan, that have deemed construction to be non-essential, there are exceptions for public infrastructure, housing, and healthcare projects. Looking at the bottom group, there's a large group there of states that have not entered statewide orders. And that means that in those states, there's a sort of a hodgepodge of local, citywide, county, even at the town level, rules as to whether construction jobs and construction projects can proceed or can't proceed. And what we've been fielding are calls from clients in different jurisdictions, trying to understand in their state what counties or what cities are they able to continue to work in, and where are they potentially not allowed to continue to work. And then another factor that we've seen is where employees who may live in one county in a state may have a rule that says construction is not essential and therefore stay home, but their job or their employer is in a county where construction is deemed to be essential. And usually the rules are written to allow that employee to go to work and go to that job. Eric, I'll turn it over to you.
Yeah, so right now in this environment, everybody everywhere is losing money left and right, and everyone is kind of scrambling to understand what the consequences are going to be and how to apply all these various rules. But one thing is for certain, that buck is going to stop somewhere, and someone's going to absorb the cost of all this extra time and lost productivity. So during this presentation, it's impossible for us to address all of the potential contracts and the various situations that exist out there. And they're jurisdiction specific, so there's so many different rules that apply to so many different projects. So what we're going to try to do in this presentation is to just kind of highlight some of the issues and draw your attention to potential issues so that you can be on the lookout for those and keep them in mind as you're evaluating the projects that you have ongoing. So we're going to talk about what can you do to mitigate your risk and ease the financial consequences that may come out of this. What does that mean for the contracts you have ongoing? What does it mean for your employees? And kind of the overarching concept of this is that this is a time to work together with your clients, to work together with the general contractor, to work together with the owner. We do not view this as a time to take contractual language and flex it and show our muscles and say, here's what we can do to you under the contract. Rather, we think it's important to be educated about where your exposure is in the contract, where your strengths are in the contract, but ultimately to use those as a background to negotiate with the other parties, the other interested parties on the job, to make sure that we can all get the job done and avoid as much loss as possible. In the construction world, we always go to the contract first. So we always want to take the contract that applies to the job and we start there with that language to find the answers to these questions. The contract language is going to govern to some extent how these sorts of risk of unexpected events like this virus pandemic, how those risks are allocated amongst the parties. And some contracts are going to be better for the sub, some contracts are going to kind of gloss over it altogether, but ultimately we go to the contract to find out what it says first and foremost. And we take that contractual language and we take the deadlines and the schedules and the requirements that are in there. We identify what's problematic in the current situation, and we go and we start renegotiating those terms and we start talking about those terms with the general contractors and the owner now. We do not want to wait until the project is 6, 9, a year late and everyone is pointing fingers at everyone else and there's a ton of money that's lost and potentially liquidated damages on the table. That's not the time that we want to be talking about this. We want to start the process of negotiating these terms and working on the schedules and identifying these problematic issues now. You know, the other issue, we talked about all these judicial emergency orders that are entered in jurisdictions all over the country. It's not clear whether any of those judicial orders that are delaying filing deadlines, et cetera, would have any impact whatsoever on the deadlines and the requirements that are inside private contracts. And in fact, they probably don't. So just because the court system in your local jurisdiction has said deadlines are extended for the next 90 days for filing things in court, that does not mean that if you've got a 5-day deadline in your contract that private contractual deadline has been altered whatsoever. There's tons of potential sources of delay, and we could probably add hundreds more items to this list, but these are just some overviews that we've seen come up already. We've got obviously the shelter in place and the stay-at-home orders that are disrupting people's ability to do work and get to work. We've got the labor shortages that are coming up as a result of those shelter in place orders and sometimes being affected by that interplay between jurisdictions and what's essential and what's not. We've got these new labor laws that we'll talk about briefly later that give some brand new rights to take leave to employees that will affect millions of employees across the country, and that may result in some labor shortages as well. To the extent that you're relying on labor from other areas to come in and travel and things of that nature, there's travel restrictions in place around the country that can disrupt the ability to get labor on site. Certainly there's supplier and material delays as a result of factories and other facilities that have had to close down. We've got shipping delays that are the result of not only the social distancing orders and those related things, but also just the increased demand that's been placed on the shipping companies who are working overtime to meet the increased demand of everyone working remotely. And then there's just sort of a lost productivity that's related to that, all of that sort of uncertainty, and people don't know what's going on, and folks don't know if they should come to work or not, and they're uncomfortable while they're there, and everyone's distracted and worried about what's going on. You've got lost productivity that's coming as a result of the social distancing requirements that are taking place on the job site, where guys, you got workers trying to keep a certain distance between each other that's making it harder to do the things that they would normally do. And then, of course, there's increased time that comes with the sanitation requirements of making sure to keep the job site as clean as possible in accordance with the CDC guidelines. And then, obviously, and this one's the most tragic, but there's, an increasing number of people in the country that are falling very ill. Some of them may be your workers, some of them may be their close family members. Some of it may just be people that they have come into contact with, and as a result, they must now self-quarantine themselves. These are all the sorts of things that can be sources of delay. I've put a chart over here just to kind of give you an idea of how much more severe the impacts on the workforce are as compared to the regular seasonal flu that we deal with most every year. And as you can see, it is exponentially greater impacts from the COVID-19 pandemic than what we have seen in the past. So when we go to the contract, we first want to find out what are the notice requirements. We know that we've got impacts, we know that we've got delays, we know that the schedule that existed a month ago is no longer going to work. And so the first step is, what does the notice need to look like? And this is not the time to sort of skirt around that and say, well, we've always just emailed with the project manager and it's been no problem. There's so much potential cost and delay associated with this pandemic that we want to make sure that we go to the letter, cross every T and dot every I to do the best that we possibly can to protect the subcontractors in these situations. And so that means if the notice requirement in the contract says it needs to be in writing, hand delivered, certified mail, we want to absolutely do that regardless of what the practice on the job site may have been before. There's big numbers involved here and huge liabilities, and everything that we can do to make sure we protected ourselves in compliance with the contract is to our benefit. So I'm going to quickly cover requests for extra time, notices of delay, notices of extra cost, notices of unforeseen circumstances, and the importance of making sure that we protect ourselves by documenting these things in real time and as quickly and as thoroughly as we possibly can as soon as we become aware of them. What we have here is just a couple of examples of notice provisions from some of our clients' contracts. And the variation in what these notices provisions might look like are as wide as your clients are. So there's an enormous amount of potential variation in how these are. But here's a couple just to show you how these are different. This is the same client working in the same region that has these various different notice requirements. And the project manager for our client that's working on these has got to be familiar with how these vary for each job and make sure that he's complying with those. So in the first example, we see that mailing or delivering written notice is okay, but also sending through email as long as you get a delivery receipt. So that's unique. In order to get a delivery receipt on email, you kind of have to take an extra step in the email process to make sure that that comes through. But in this case, email is fine. In the next example, email is not fine. In the next example, you can do hand delivery or overnight courier to an executive officer of the general contractor, or you can do it by mail, but you can't do it by email and you can't do it by fax. The general contractor can put the subcontractor on notice by fax, but it doesn't go the other way. And that's interesting. The other interesting part of this one is that if it's sent by the mail instead of hand delivery, the notice is deemed effective the second calendar day after mailing. If you've got a 5-day notice requirement and you don't mail it out until the 4th or 5th day, that notice is going to technically be delinquent because it's not going to have been deemed effective until 2 days after it was mailed. So these are all the things that you've got to take a look at and have in your mind at all times and from the outset so that you can make sure you're doing your best to comply with these. The next one, that third example, is another one that allows the communication to be emailed, hand-delivered, or sent as a fax. But if it's mailed, then it's only deemed effective 3 days after mailing. And again, there's a difference between these two contracts and when these notices become effective of a day, only one extra day that could have some serious consequences for whether or not the notice was timely given. Turning to notices or requests for extra time, putting the general contractor on notice that the project has been delayed. It is undoubtedly clear to everyone that's out there on the job site that things are going slow, that there's going to be delays, that things are taking longer than usual. But do not assume that the general contractor or the owner are going to understand that and give you the extra time. You want to make sure that your stuff is documented, because a year or 2 years down the road, when this project wraps up and it's late and there's claims being made for extra time and general conditions, you want to make sure that you've done your absolute best documenting and papering your file to avoid as much liability as possible. So this is an example of a notice that puts the burden on the subcontractor to let the general contractor know if there has been any sort of disruption or hindrance that's going to affect the ability to maintain the schedule. And that's the subcontractor's burden, even though in this situation it seems so obvious. It's still something that the subcontractor ought to be putting in writing and ought to be making sure that the file is documented with. Let's go to the next slide. Here's another example of request for extra time. Again, this one places the burden on the subcontractor to notify the general contractor in writing if there has been an impact due to any circumstances beyond the subcontractor's control that is going to impact the subcontractor's ability to meet the currently scheduled deadlines. And like many of these, the contract is going to allow that the only remedy the subcontractor is entitled to is an extension of time. But in order to make sure that you get that time that you're entitled to, it's important that you put these notices in writing and that you get them timely transmitted to the general contractor, strictly complying with the notice requirements that we covered earlier. A notice of delay. Again, this is similar to a notice of a request for an extension of time, but here we're just placing the general contractor on notice that there has been a delay and that it's not our fault. And that's a part of the contract that you have to satisfy. It's a condition precedent to your ability to seek other remedies under the contract, such as extensions of time or requests for additional money or change orders, et cetera. So you want to make sure that you put this out there as quickly as you can. In this case, this one requires that notice to be given no later than 5 days after the occurrence that's causing the delay. So you can see here the urgency of making sure that these types of notices are given as promptly and as thoroughly as possible, and they need to be re-given each time that that anticipated delay grows. So for example, if you have a stay-home order that comes out that you anticipate is going to delay your completion by at least 2 or 3 weeks, and then that later gets extended, then you need to give an additional notice that you anticipate an additional delay, and you need to do that each time that those you reasonably anticipate those delays to come up. Here's another example of how these notices of delay can vary from one contract to the other. This is an AIA form. The written notice is to be provided to the contractor immediately. And then below that, when it's talking about schedule, it talks about that you have to notify in writing within 10 days of any schedule update that there's any issues with it. And if you don't give that notice, then under this contract, you've deemed to accept that schedule, irrespective of any of the other circumstances that are going on at the time, like there are now. And again, there can be instances that come up where there's extra costs that are incurred, and that those costs may be related to additional labor costs, or they could be general requirements, general conditions that the subcontractor is incurring as a result of the sort of stretching and prolonging the job process, or later when the job is inevitably going to be compressed or stacked to get it done on time. So these notices of extra costs, same thing. These impacts that are coming as a result of this COVID-19 pandemic should not be treated as something obvious that everybody's going to work through. It's each party's responsibility to make sure that they're complying with the contract, that they're giving the notices that they are required to give on the schedule and in the manner that they're required to give them, so that you can make sure you're doing your best to protect the company and reduce potential exposure. Some contracts, not all, will have paragraphs about notice of unforeseen circumstances that are either going to expand or delay the project. And same thing, you want to make sure that you understand what those notice requirements are, and that you strictly comply with the deadlines and in the manner provided for notices in the contract. All right, Rich,
okay.
I'll turn it over to you.
Okay. And we should say that this presentation, we've provided it to AWCI, and they will be able to distribute it out to you. If you haven't already gotten it, it will be coming your way. So one thing that we've heard a lot about, and I think it's made its way into the general conversation of business people, is force majeure. That went from being an archaic term buried in the boilerplate of contracts to something that seems to be getting a lot of attention. So what is it, and what does it do, and what doesn't it do? A force majeure provision basically is a provision that says, hey, if there's some act of God, if there's some unforeseen, unanticipated, unanticipatable event that is not due to human intervention that makes your performance of your contract impossible, or at a minimum extremely difficult to perform, you may have the ability to avoid a default that would otherwise be in place because of that act of God. So let's put it into the context of a construction site or job that you might be involved in. Let's say you have an order for light gauge steel that's supposed to be delivered, and you can't take the next part of your job and start working on it without that delivery, and the delivery is not coming. And it's not coming because the warehouse from which it's coming out of has been shut down due to COVID-19 hotspot at that warehouse. So the material's not able to leave, and the warehouse itself is shut down. What are the rights of the parties there? So you, as the subcontractor, have a contract with the vendor, the supplier, and that contract likely has an act of God provision, a force majeure provision. And that provision, if it's triggered, would give an excuse to the supplier for not supplying that steel, and therefore would not expose the supplier to damages and liability for failing to supply the steel that you ordered on time. And then in your contract with the general contractor, there is likely also a force majeure provision, which may similarly give you the right to avoid liability for not maintaining the progress of the job and not keeping the schedule, not having those materials delivered on time. So when we look into the contracts, the language of the contract is going to be very important to understand and to see if it applies to an epidemic or a pandemic situation. Prior to this situation, the drafters of these contracts probably paid little to no attention to the force majeure provisions. You know, going forward that everyone's going to be really focused on them. But the language in most of these is either very general, doesn't have a lot of definition to it, or has some general language, broader language, and may draw specific reference to weather-related acts of God, like a hurricane or like, you know, a earthquake or something like that. But when we delve into the specific language, we'll see that there's going to be arguments available to both sides if it comes down to a force majeure provision as to whether it relieves performance. So looking at the next slide, here's a force majeure provision taken from a contract. And it says, subcontractor shall not be liable for a delay in the performance of one or more of its obligations under the subcontract due to the events of force majeure, but only to the extent and upon the condition that, 1, you provide written notice, and then 2, you provide contractor no later than 2 business days prior to the date of contract is required to submit notice to the owner, specifications of the problem. And you're required to provide written notice no later than 3 days after the occurrence of the event with the description of the particulars of the event, the estimated duration of the event, or the effect thereof, and the probable impact on the subcontractor's performance. So, a couple things to take away. 1, almost every force majeure provision is going to have a notice requirement. We can't just sit back and say, well, it was COVID-19 that prevented me from completing my work, and everyone knows that. You still need to give the notice under your force majeure provisions. And I'm sure that you're starting to see those come in. I understand that from our clients that they're seeing them hit their inboxes, and they're usually something fairly general at this stage. Something like, you know, dear general contractor, due to federal, state, and local government stay-at-home orders, shelter-in-place orders, social distancing requirements, and the COVID-19 problems or epidemic, we're notifying you that we may have an occurrence that triggers the force majeure provision. At this time, we don't know the full extent of it. We expect it to impact our work. And we're providing this notice pursuant to paragraph whatever under the contract. That is a good idea to do if you have any jobs where you are expecting to be relying upon this provision, or even if you hope not to rely upon this provision. This force majeure provision is really very poorly drafted. It doesn't provide a lot of protection. Going back to that first sentence, it says, shall not be liable for delays due to events of force majeure, with no definition. And that term is not universally defined in the law. That doesn't mean a whole lot. Let's look at the next one.
Well, before we go to that one, I was going to say this term not only requires notice under this contract, but it also requires the subcontractor to cross-reference the prime contract and meet the deadline 2 days prior to the deadline in the prime contract, and that the force majeure claim is consistent with how that may or may not be defined in the prime contract. So this one's got cross-references in it that you'd have to comply with as well.
Right. And we often hear, well, we don't have the prime contract. You almost always have the right to request a copy of it from the general contractor. Now, whether they give it or not, that's another thing, but just requesting it, and if it's not given, can give you some protection from having to comply with the prime contract terms if they don't hand it over. Okay, let's look at the next one. And this is a force majeure provision that I believe we were looking at earlier in the presentation. But on this one, I just wanted to draw your attention to the language, and I'll read it. the relevant part, should the subcontractor be delayed by any cause, including by the combined action of workers or by government directive or order, or in no way chargeable to the subcontractor, or by any extraordinary conditions arising out of war or government regulations, or by any other cause beyond the control and not due to any fault, neglect, or omission of subcontractor. And then it goes on to say you can get an extension of time of your contract. But here we've got some language that can give us a toehold into a force majeure claim. Those would be where it's due to government directive, such as a stay at home or shelter in place, or social distancing that makes the work impossible or extremely difficult to perform. Same for any act of a government regulation, which to the extent that the government actually says you are non-essential in your area and you cannot work, that would cause a fairly, I think, straightforward triggering of this force majeure provision. But you got to give the notice, and you have to give the notice within 48 hours of the event under this. So now is the time to review those contracts and get your notices out. The final one that we have to look at on force majeure is the AIA form language, which falls into the general, not very helpful for COVID situation. So if the contractor is delayed at any time in the commencement or progress of the work, and then it says by any cause beyond the contractor's control. That's the extent of the language. Now, clearly, the fact that there's been a pandemic, the fact that there's been stop work orders by the government are beyond your control, but this just leaves open more opportunity for an argument because it's not as specific. The best language we've seen has actually referenced pandemics. There's been some language that actually contemplated pandemic, but that is few and far between. Okay, the next issue is these contracts that we're all operating under, how are they terminated? And almost every contract will have a termination for cause, which is on the left side of your screen, and a termination for convenience on the right side of the screen. And that's at the convenience of the general contractor, not the subcontractor. So the termination for cause could come into play if the general contractor believes that you are unable to supply enough skilled men or materials to maintain the progress of the job. And that again can be a situation where you would pull out the force majeure provision and say, yeah, but I'm excused because of the situation with the pandemic. On the right side is where the general contractor can terminate the contract for no reason. And this doesn't have to necessarily have anything to do with the pandemic, but in every contract, the general contractor can simply pay you for the work that you've done, pay you your retainage, and sometimes pay you for some demobilization charges and terminate the contract. You're not entitled to the profit that you lost on the job. You're not entitled to, other damages that may flow from that. So keep that in mind, and that may be triggered in the event that, let's just say, the owner has a change of heart. It's a new project, it's just getting started, and the owner says, under these economic conditions, I am not going to go forward with this project, and exercises its right to terminate the prime contract, and that would trickle down to your contract. So be aware of those termination provisions. Subcontractors generally do not have a mirror image right to terminate the contract at their convenience. Next topic, next page. And this is language that we all know is in these contracts, your subcontracts. It's the obligation to comply with all safety laws and requirements. But in the context of a pandemic, they take on new meaning. And under these provisions, you typically agree to comply with all federal, state, municipal, local ordinances, rules, and regulations. And when we enter these contracts, we're thinking, sure, OSHA, safety standards, and things along those lines. But now we've got ordinances, rules, and regulations about social distancing and other pandemic-related protections that are in place. And in this contract, the top provision, you, the subcontractor, are agreeing that that you will not seek a claim for any damages arising from your compliance with these safety laws and provisions. So that's language that we would argue that did not contemplate the pandemic, and that the subcontractor should not be held holding the bag for all of the costs and expenses associated with the compliance with these safety requirements, and can seek some relief from the contractor for extended general conditions, additional costs, and the like under the contract. And then the bottom provision is another one, simply where subcontractor agrees to comply with all safety requirements that exist on the job or required by the government. So next page, payments. I was listening to the webinar that was held by AWCI on Monday, and I heard some comments about, we're not really seeing slow payments coming in. I don't know, because this isn't an interactive webinar, whether you are or not, but we're at the very beginning of this, and unfortunately it looks like it's going to go on longer than we want or expect at the beginning. So we're going to see at some point slow or partial payments. We're going to have situations where there's an inability to meet contractual requirements, maybe even to submit a pay app. And that could come in, let's say, if one of your jobs is stopped and you had a milestone of completing a certain percentage before you can submit your next pay app, or requiring an architectural sign-off to view the work on the job in order to approve the pay app, and the job site is no longer available. There could be problems with physically getting checks out from offices where people aren't allowed to go to process the payment. There could be other issues that prevent payment or slow payment. So in these times in particular, we're just going to do a quick refresher on some of the things that we always talk about, which is look out for those waivers and releases that are in pay apps and lien waivers, and other contract provisions that will come and bite you if you're not careful when you're submitting your pay applications and seeking payment. General contractors often have in the contract some language that allows them to hold back money if there's a reasonable concern about your default or ability to complete the project. They may use that if they're trying to conserve cash on their part. And state laws about prompt pay may be on hold by these judicial emergency orders. It's going to be, again, a state-by-state analysis, and a big question as to whether a court can change legislation by saying all requirements under statutes are stayed. But if there's a stay in place, and you got a Prompt Pay Act that says you get paid in 7 days, but the court says, hey, everything stayed for 30, 60, 90 days, there's a good chance that you're going to be in a fight with your general contractor about getting your money released to you. All right, quickly going through these waivers on the next page. Here we've got 2 pay apps, and we've highlighted in there so you know some of the things to look for. This is a sort of a standard pay app, which has, hey, by submitting this pay app, you are waiving all claims for any additional compensation of any kind, including delays, disruptions, interferences, accelerations, any other claims except those that you identify and specifically list out. Take the time, list them out specifically. And both of those pay apps have similar provisions. Now, both of these are good in the sense that they actually draw your attention to it and have a place where you can actually fill out and put in the claim. And put in as much as you can on the claim, but if all else fails, say, you know, something like delayed due to pandemic, COVID-19, assessing damages, you know, reserving all rights, just something to put it out there. And if you've got a pay app that doesn't give you the right to submit claims or identify exceptions from the release, cross out the language and submit your own writing out those claims that you have. Do something to protect it. Next page is some language in various contracts about change orders. And often change orders, either on the face of the change order or in the language of the contract, says anytime you submit a change order, you are waiving all rights to any amounts associated with that change that aren't reflected in the change order. So again, be careful about that. In your change orders, put in language that calls out or holds a placeholder for plus additional delays and impacts due to resequencing or additional time due to the pandemic, something along those lines to preserve your rights. And then the next page, the pay when paid and pay if paid language could come into play here. Again, pay if paid is the top language, and that in the states that allow it, the jurisdictions that allow it, says if the owner doesn't get paid, then you, the subcontractor, have no right to payment. It's a condition precedent to payment. The bottom language is pay if paid. I'm sorry, the top language is pay if paid. The bottom language is pay when paid, which says, oh, I reversed that again. The top is pay when paid, which says, hey, you get paid following 10 days from payment, and that's just a timing issue. Some states will allow that. A lot of states will not allow the pay if paid, which says you only get paid if we get paid. And if we don't get paid, the general contractor, then you don't get paid at all, subcontractor. So be aware of those, and especially if we've got some defaults from owners coming down. Next page, liens. Generally, the guidance here is for liens, comply with the statutory timelines that you have for liens. Do not assume that they are extended. If you are in a position in a state where you cannot physically file the lien because the courthouse is closed or the system is inaccessible for whatever reason, document your efforts to file that lien regardless. If there are defaults coming down, and if there's bankruptcies coming down, which we don't know and we hope it's not going to happen, the lien is your best protection to get value for your work because it's secured by the property and not by the ability of the companies that you're working for to pay. Next page is similar situation for performance bonds. You've got performance bonds on your job that benefit you. In other words, if the general contractor doesn't pay you, you have the right to assert a claim on a performance bond that's backed by a large insurance company. That is also going to be very protective for you. And you want to make sure that, one, you get a copy of the performance bond, and you can get that by asking the general contractor for it in almost every contract. Two, you take a look at the conditions and terms to see if it's triggered. Three, you give them the required notice. And four, if you're in doubt as to whether to file a bond claim, go ahead and file the claim. You can always withdraw it, make your claim on the bond, preserve your rights, do it as timely as possible. Eric?
Thank you. So real quick, the statutes may also come into play. So we talked about the force majeure provisions that exist in the contracts and how those are read and how they apply. Many states also have a statutory force majeure that's sort of written into the contract by law. This example is from Georgia, and the examples across the states are going to vary. But in this example from Georgia, if the performance of the terms of a contract becomes impossible as a result of an act of God, then such impossibility shall excuse performance, except where it could have been avoided. So very similar to the types of force majeure provisions that are written into the contracts, but this one, by virtue of being a statute, is incorporated into the contracts by law. So even if you have a contract that doesn't have a force majeure provision in it at all, you may also be able to look to the law of the jurisdiction that's applicable to find out if there's some statutory force majeure provisions that could be applied to the situation. So shifting gears very quickly as we're running out of time into some of the new labor laws that have come out and the labor issues and how that pertains to you as an employer. We've got two main things. We've got the Families First Coronavirus Response Act that became law on March 18th. That expands the Family Medical Leave Act and provides for some unique emergency paid leave. And we'll go through that in a little bit more detail. And then we've got the Coronavirus Aid, Relief, and Economic Security, the CARES Act that became law on the 25th. And that's the largest financial bill that's ever been passed in the history of the country. It provides $2 trillion in financial assistance. And we'll talk about, there's lots of provisions of these laws, and we're not going to have the ability to cover them all, but we'll talk about a few key points that apply to you as employers. Under the Families First Act, the FMLA expansion, this is unique because this applies FMLA in ways that it may not have applied to you before. So, you know, your prior labor advice on the applicability of FMLA to your provision is and may be modified by these new statutes. But under this expansion, if you have fewer than 500 employees, it applies to you. And you're required to provide up to 12 weeks of job protected leave for employees who are unable to work because they're caring for a child who's out of school. And across the country, that is many, 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 many parents, including me. And so that potential impact of that FMLA leave for the parents that are now homeschooling their children while the schools are closed is enormous. And an employee is eligible for that leave if they've been employed for 30 days. So this isn't just your long-term employees that have sort of earned this ability to use this benefit. This applies to people that you hired as recently as a month ago. If it's a coronavirus related leave, then they get paid 2/3 of their regular rate of pay. And that's capped at $200 a day. And then there's a $10,000 cap on the total under this law. The emergency paid sick leave, again, is unique. This is brand new law. It requires employers to give paid sick leave under a number of circumstances. The first three are one type, and the second and the next are a different type. Under the first three, if they're under a quarantine order, which is different than a shelter-in-place order. Quarantine order, that's going to be someone who has been ordered to quarantine because they have either been diagnosed with coronavirus or have been exposed to it, etc. Number two is they've been advised by a healthcare provider to self-quarantine due to coronavirus, or they're experiencing the symptoms of coronavirus and seeking a diagnosis. That's relevant because of the shortage of tests. And the symptoms of coronavirus are very similar to at least the early symptoms, very similar to those of the flu or the common cold. So there are a lot of employees that might potentially qualify under that section as well. If under those first three provisions, an employee takes emergency paid sick leave, then the employer is required to pay the regular rate. And that's capped at $511 per day, and it's for a total of $5,110. That's paying that employee exactly what they would have paid up to $511 during this period of emergency sick leave. 4, 5, and 6 are caring for an individual who is under a quarantine order or has been told that they needed to self-quarantine by a medical provider. And number 5, caring for a child whose school or place of care has been closed. And then number 6 is experiencing other similar conditions, and that is referencing some HHS laws and Secretary of Labor laws that are just too detailed for us to delve into in this webinar. But under those circumstances, then you're required to pay 2/3 of their regular rate, which is capped at $200 a day. So again, under that provision, that emergency sick leave, you have employees who would be entitled to take up to 10 days of paid sick leave at 2/3 their rate of pay, up to $200, just to stay home with their children who have been who are out of school. There's some cost mitigation in there for employers in the form of tax credits, and then some other delays that we'll talk about with the next law to kind of help offset this. But the bottom line is that if you've got less than 500 employees, you're probably going to have employees, if they haven't already, that are going to take some of this leave.
Okay, this is our last topic here, and one that I think deserves a good bit of, attention from every small business owner, and small business being 500 employees or less. But this is the most recent piece of legislation that came down on the 25th, the PPP Payroll Protection Program, and the Economic Injury Disaster Loan, which it expanded the benefits of, and then payroll deferrals and estimated tax payment deferrals. So the most interesting and potentially beneficial part of this is the next page, which is the PPP program. The federal government has made $350 billion worth of loans available to small businesses. They're going to be administered through the SBA, but through your local bank. So any bank that issued small business loans before, starting April 3rd, which is 2 days from now, is going to be taking applications for these. The extremely good part of this is that the loans are forgiven if the money is spent on payroll, paying your business rent, your business mortgage, interest on other loans that you have, paying sick pay, medical leave, family leave, group health benefits, utilities. The forgiveness is not going to be taxable income. Unlike other debt forgiveness, this is simply money coming from the government that you're not going to have to pay taxes on. Forgiveness is based upon employers maintaining or quickly rehiring employees and maintaining salary levels or close to the salary levels. Now, if you've let people go, or if you have to let people go before this money comes, you can hire them back or hire most of them back and still qualify for a significant portion of these benefits. You can also reduce salaries some and still qualify. Forgiveness will be reduced if the full-time headcount declines or if salary and wages decrease. There's no personal guarantees. There's no collateral required, and there's no fees that are charged. The purpose is to provide 8 weeks of cash flow assistance to small businesses as an incentive to keep workers on the payroll and keep them from hitting the unemployment ranks. You can get up to 2.5 times your qualified payroll. And they look back, I believe it is to mid-February, look at your payroll, do a calculation off of that, and that's how the max of a loan you can get. And that's capped at $10 million per business. Any loan amount that is not forgiven has a maturity of 2 years and an interest rate of 0.5%. So amazing terms there. And this will close, the availability of this will close currently as of June 30th, 2020. There's a lot more to the CARE Act, a lot of beneficial tax benefits, both for this year and importantly, years going back that may require you to file an amended tax return to immediately get cash back now. So we ask that you check with your CPAs, and as this becomes better understood, see what you can do for your business there. Then the next page is the Economic Injury Disaster Loan Program, which came out, seems like a long time ago, but it was really about 3 or 4 weeks ago. these are loans, true loans, for businesses to aid in the recovery from a disaster, such as this pandemic. Low interest, long-term loans, up to $2 million, typically on a 30-year repayment. No payments due for 12 months. You do have to submit financials, tax forms, tax filing records, things along those lines. 3.75%. These are not forgiven, but they are for longer term and can be used for more purposes and for more money potentially. And you can do both. Importantly, you can do both the PPP and the EIDL loans. Next page is, I think we've all heard this, but worth repeating, that any tax payments, payroll tax payments due between March 27th and December 31st have now been deferred. And the idea is to put more cash in your pockets so that you can keep your employees paid and your businesses running. Those are deferred half until December of 21 and then half until December of 22, so a good period of deferment. And then lastly, the last page, companies that owe taxes and have tax payments due on April 15th, both the 2019 tax payment and the first quarterly tax payment for 2020, those have been postponed until July 15th at the federal level. Check with your local CPA for how your state is treating them. A lot of states have mirrored that. Okay, so in summary, we are in uncharted waters. That's goes without saying, and there's a lot of uncertainty. The law is changing daily. The financial and economic impacts are changing daily. Hopefully it's going to start changing for the better. We suggest that when in doubt, comply with your contract provisions and regulatory and statutory timelines. Do not assume that things are going to be pushed by government or court rules. Good opportunity to negotiate and keep your communications open with your customers. Try to work out agreements is always the preferred way to go at the front end. Read and understand your contracts and the provisions that we've been talking about. Obviously, stay up to date on the labor issues that Eric was covering, and do take advantage of these federal loan and recovery measures that are out there to help your business. So with that, I think, Eric, you wanted to talk about this for a second.
Yeah, well, it's just, do we have any questions? But this is just an interesting Google search that is kind of what's autofilling here, sort of the mood of the country, as it were, of what people are thinking about and what kind of searches they're running and asking about this. And it just sort of illustrates the vast unknown and fear that exists with this virus, and where things are going to go from here and how long it's going to last. It's really unprecedented. So with that, I don't know, we've kind of used up our time, but if we have any questions or anything, I don't see any that have popped up.
Oh,
And also if there are questions.
Go ahead, Rich.
No, I'll say if there are questions that come in after, we can respond to them after the completion of the webinar too.
Awesome. So one question, if both of you had a crystal ball, what changes do you anticipate seeing in GC's contracts going forward for new construction?
Well, I think that the main thing I think that's going to draw attention is the force majeure provisions. We're going to see more focus on that, and probably once this all sifts through and we figure out who got hit with the heavy burden, there will be some effort in the contracts going forward to more evenly spread that burden between the contracting parties. When it comes to a pandemic, unfortunately, it's probably not the last time we're going to see a situation like this. It might not be for a number of years, but now that it's anticipated, once things happen, they tend to find their way into contracts, and we will see some force majeure language in place that addresses it. I think that's the most likely.
Thank you. Okay, I don't see any questions. So with that, on behalf of AWCI, I would like to thank all the attendees for joining us today on AWCI's Convention and INTEX Expo Reconstructed. Thank you to Eric and Rich for sharing your knowledge and your time with us today. We know that in several more weeks we'll be meeting again with you to kind of see where we're at then with temperature-wise in the construction world. And as a reminder, this webinar was recorded, and all attendees and speakers will receive a link to AWCI's online library following the conclusion of today's broadcast. And be on the lookout for emails with details for upcoming AWCI's Convention and INTEX Expo Reconstructed events over the next few weeks. So thanks again, and have a productive day, and stay safe, everyone.
Thank you.
Thank you.